Hello, everybody. Welcome back to the Antonio Sledge Vindication Tour. I think this is the third video. This relates to what I think was the second video, in which I discussed the fact that Antonio Sledge did not have a conviction for possession of a firearm by a convicted felon in his 2015 case, as was alleged at his probation revocation hearing. So I'm going to re-show the part where the probation officer talks about that case. You'll have already heard it if you listen to that part. But what we're interested here is the way Attorney Abate props up that misstatement of fact with a misstatement of his own. So this is essentially the second layer of misrepresentation of fact relating to the non-existent conviction for possession of a firearm by a convicted felon. So I'm going to play the clip. I'll pause, I think, once to explain one thing as we go. But here we go.
The next case is 15 SC 138994. That is a Fulton
Some of you may remember this as the Alford plea case from the YSL trial.
County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. This
is the one we're focused on, possession of a firearm by a convicted felon.
January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
Yeah, natural question. Judge Whitaker wants to know what the convicted felon part of the possession of a firearm by a convicted felon was, which is a natural question to ask. Of course, given that there was no possession of a firearm by a convicted felon, there is no possible correct answer to that question. It's like asking, you need an engine to make a car run, right? And so it's like asking, what kind of engine does that car over there have when there is no car over there? You can't possibly answer the question. It doesn't make sense. There is no car, so it can't have an engine. Same thing here. There is no possession of a firearm by a convicted felon, so there is no underlying felony because it doesn't exist. I probably over-explained what was a pretty simple concept there. But yeah, there is no possible answer. And any answer that you give is going to be incorrect. It doesn't matter what it is. There is no possible correct answer. So surely nobody's going to answer that question.
Or are we missing a felony?
Or are we... I'm not going to comment on that.
One moment.
We're not missing a felony. We have an extra felony. We actually have several extra felonies. That's where the confusion is. Again, I do want to say that, again, I don't blame the probation officer for this. She's just reading a report.
That will be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So hang on. So the 15 SC and then this 22 SC case, right? Is there anything between the two of them?
there's nothing in between the two of them now.
Okay.
Nothing between 2015 and 2024. Or 5, I guess. Again, everyone's confused because the question has no answer. There is no underlying felony because there is no felony. I mean, there are other felonies, but there was no possession of a firearm by a convicted felon. No possible answer can be given. So surely nobody's going to answer. Awkward silence.
Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it.
I may explain this one at some point. It's complicated.
One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I
SC.
figured there had to be something else.
Objectively false. Demonstrably false. Easily demonstrably false. It takes 2 seconds to prove this false. This is... Oh, let me switch this over so you can see. Okay, so this is the 15 SC case that is the case in question. This is, as you'll see, the case where there is no possession of firearm by a convicted felon, or 16-11-131. Let's scroll through these. And then to the second page, 106, 15-4, 106. There is no 16-11-131, just to confirm. That's the case number there. 138994. And so because there was no possession of firearm by a convicted felon, there could not possibly have been a predicate offense or a predicate conviction. As a result, the statement made by the state that the 13 SC case was the predicate offense or the predicate conviction is impossible. It cannot possibly be true. And I don't want to malign the prosecutor in the clip, but I, for the life of me, can't see any good faith basis for the making of that claim. Simply because if you have, you shouldn't be making statements about the predicate conviction or about any particular conviction in general, unless you've looked at the sentencing sheet so you can see, what the convictions are. Preferably, you'd also look at the indictment. But so that is an inaccuracy. There was no 131, and as a result, there was no predicate to 131. So that statement was completely demonstrably incorrect, provably incorrect. Again, I'm not making arguments here. It's just a verifiable fact, an easily verifiable fact. And it was a fact that was misrepresented in a hearing that ultimately cost a man 5 years of his life. Well, we'll see if that actually comes to pass. The next video will actually be about this same 131 conviction that doesn't exist. So yeah, I'm going to record that now.